You'll hear argument next in Case 12-761, POM Wonderful versus the Coca-Cola Company. Mr. Waxman.
Mr. Chief Justice, and may it please the Court, the Lanham Act provides a remedy for businesses whose market is misappropriated by competitors that misrepresent the character of the goods they sell. This case presents an egregious violation of the law. Coca-Cola's label grossly misleads consumers as Coke anticipated, but Coke says that it need not answer under the Lanham Act because its label is authorized by FDA regulations. The label is not, in fact, authorized for reasons we explain and with which the United States largely agrees, but even if it were consistent with FDA regulations, that would not strip POM of its right to prove a willful Lanham Act violation. Courts are obligated to give full effect to congressional enactments wherever possible. Here, Congress has never precluded or conditioned enforcement of the Lanham Act in food labeling cases, and it is entirely possible, in fact, entirely easy, for Coke to comply with both statutory obligations.
If there is no private cause of action to enforce the FDA label standards, only the FDA can bring a proceeding to say that an ad violates its regulations. How does a court below, without interpreting the regulation, go about deciding whether or not a particular ad doesn't comport with the regulations and hence would be subject to the Lanham Act?
Justice Sotomayor.
Maybe that's a better question for the SG, but I'm trying to figure out.
Well, let me take a shot at it, and
so do you concede that a Lanham Act plaintiff could not challenge aspects of a food label that the FDA said is required?
Well, Justice Kennedy,
I know that's not this case.
Thank you. Let me just say, not only is that not this case, because the FDA has never examined
I want
the
your
label,
answer to the question. Yeah.
My answer to the question would be —
Kennedy's question, I think, was different. He said, suppose that it said, you're required to use this label and only this label. Then you would acknowledge that there is an impossibility issue. Is that right?
Yes, unless, as in Wyeth, there was, in fact, some possibility to change the label. But
why isn't there a different kind of conflict here? Let's just focus on the name, which is what the Solicitor General says the FDA has considered and has specifically permitted, that they went through this very long and involved process and they decided exactly what kind of names were permitted for this kind of product and what were not permitted because they constituted misbranding. And essentially, the FDA has said, this is what counts as misbranding, nothing else counts as misbranding. And now you're coming in and under a Lanham Act claim saying, no, the FDA is wrong, this is misbranding. Why isn't that a problem?
Why isn't that a problem?
Yeah. The FDA has said it's not misbranding. You're saying it is misbranding. That seems a quite direct conflict as to what the FDA says versus what you are alleging under the Lanham Act.
So we know that that is not, in fact, how the FDA construes its regulation, and we know that because just by examining the FDA's own limited enforcement history, all the parties have cited the
Well, just hypothetically, let's say that the FDA said that this name was not misbranding, that this name was fine under their regulations, that they did not count as misbranding.
So we are challenging the label as a whole, which is covered by under the FDA.
No, so I understand that you would have some claims about different parts of the label, but I'm only asking about your claim as to the specific thing that the FDA ruled on.
19 and 2920 of Federal Register 58, we warn manufacturers that even compliance with this, where there is a small amount of the non-predominant juice named, has great capacity to mislead, and we encourage, twice in the rulemaking, we encourage manufacturers nonetheless to name the juices in the product. Coke well knew and intentionally designed a label that, in fact, grossly misleads consumers to the economic disadvantage of the company that, in large part, created the market.
What would be the the components of the injunctive relief that you would seek. Assuming you have a Lanham Act claim, what should Coke have done to make its product non-misleading?
Well, we haven't, in the course of our complaint, we didn't specify, the injunction that we would seek is ceasing to use the label as it currently exists. And of course,
without saying what label would be lawful.
I'm sorry.
Suppose the percentage were a lot higher. Suppose it was 50% pomegranate and blueberry.
That a substantial number of consumers are not only misled, but misled to the detriment of our product. The eyedropper's worth of pomegranate juice that's in the half-gallon bottle, there were 2 microns. The question simply is whether a manufacturer like Coca-Cola can design something that it knows runs a substantial risk, quote, from a misleading perspective. And the evidence shows that over a third of consumers who look at this label believe that pomegranate and blueberry juice, in fact, are the majority juices.
But what if it were the case that there are a very small number of people who are allergic to one of these ingredients? I'm not suggesting it's true. For all I know, it's not. But let's say there are a few people who are very allergic to pomegranate juice or blueberry juice. And so the FDA says if you put even an eyedropper full of that in your blend, you have to put that prominently on the bottle so that these people will not inadvertently get an allergic reaction. Could you have a Lanham Act claim then?
Well, of course, the only thing that consumers know is that from the front label is that there is arguably pomegranate juice and blueberry juice in here. So the question would be whether they had to disclose on the label that there was also 0.01% strawberry juice or 99.4% apple and grape juice.
Thank you, counsel. Ms. Sherry?
Mr. Chief Justice, and may it please the Court. If I could start with the naming aspect of the case, Justice Kagan, you're exactly right. We have a circumstance here where we have 2 federal statutes that cover the same subject matter, that apply functionally the same standard to the same words on the same product label. Under the FDCA, we have an authoritative interpretation of that language by the FDA. 102.33 is a regulation that was reached after extensive rulemaking proceedings over the course of 25 years.
What public health benefit is served by this regulation? This is what puzzles me about it.
The regulations it comes under the misbranding provisions of the FDCA. So 343 focuses on misbranding. It has a number of subsections, one of which gives the FDA authority to establish common or usual names of products. And the purpose of that is to have some form of standardization so that when a consumer goes to a marketplace to purchase a particular product, it knows what's going to be in the product. And in fact, that was the purpose of the very regulation.
Except I'm not sure that, the argument is you can't even taste these flavors. And that's their point, and you're taking a contrary point, that flavored doesn't mean what you taste. Flavored means something else.
No. The point is, and I think the argument that Petitioner is making has to do with the particular facts of this case. The argument is that because there's only 0.3% of pomegranate juice, that it is not actually enough to flavor the beverage, and that's a factual question that could be resolved on remand. But Petitioner's argument with respect to the name would be exactly the same, Justice Alito, if there was 10% of pomegranate juice in this product or there was 15%. In Petitioner's view, a Lanham Act claim could still go forward in those circumstances because there would be no irreconcilable conflict.
Do I understand your position to be that if the label is specifically authorized, then the Lanham Act is precluded. But if the FTC has just simply failed to forbid it, it is not. Is that your distinction you draw?
I think so, if I could just articulate it slightly.
Because if it is, I think it's very hard to work with.
Very applied to this case. So we have, you said the name is okay, pomegranate blueberry flavored. But you say the label is something different from the name, and the Lanham Act can apply to the label. So what parts of the label are you saying are not touched, are not preempted by the by the FDA laws.
We're drawing a distinction. When we say the name, we mean the actual words themselves, pomegranate, blueberry flavored blend-of-5 juices. When we talk about the label more generally, we mean how those words are presented on the label and other aspects of the label.
What if the label just had the name on it, nothing else? Could they still sue on the ground that the label was misleading?
Not unless they were able to point to something else on the label that was misleading aside from the actual words in the name.
Does the FDA take into account purely commercial confusion when it issues when it issued its regulations governing the label? Or is it limited solely to what I would expect, the health and well-being concerns?
It absolutely took into account consumer confusion. There were comments with respect to this particular regulation, and the commenters were consumers saying that they were concerned that they were being misled with respect to the juice content.
There's no irreconcilable conflict if we view what the FDA has done as just setting a floor. And you talk a lot about how, the FDA specifically considered this and it decided not to do this. You put a lot of emphasis on process. And I guess my question to you is that the way you're saying we should know whether the FDA has only set a floor or instead has also set a ceiling, that we're supposed to look to the process and figure out whether the FDA specifically rejected a more extensive proposal, a more aggressive proposal?
No, I think you look to whether or not allowing the claim to go forward would complement what the agency has done or would actually conflict with what the agency has done. And here we think there is a real conflict. We're not talking about supplementing the agency's enforcement resources. We're talking about supplanting their regulatory judgment.
Well, I guess I don't understand that. Why wouldn't it complement? You've said here's the floor to make it not misleading, but, we're not saying that there are some things that, wouldn't mislead a lot of consumers anyway. And then the Lanham Act can come in and supplement that and really put us in a position where nothing's misleading at all.
For two reasons. Number one, because the agency considered why manufacturers would want to actually name their product based on the flavor, because consumers actually do care about the flavor and they care about the taste. The product had been named apple grape juice, for example, and it in fact tasted like pomegranate blueberry juice. A consumer might be very surprised when he came home and had a sip of that juice and realized it tasted like something very different.
You don't think there are a lot of people who buy pomegranate juice because they think it has health benefits, and they would be very surprised to find when they bring home this bottle that's got a big picture of a pomegranate on it, and it says pomegranate on it, that it's, what is it, less than 0.5% pomegranate juice? The FDA didn't think that would mislead consumers?
Is it part of Coke's narrow position that national uniformity consists in labels that cheat the consumers like this one did? I think it's important for us to know how these statutes work. And if the statute works in the way you say it does, and that Coca-Cola stands behind this label as being fair to consumers, then I think you have a very difficult case to make. I think it's relevant for us to ask whether people are cheated in buying this product. Because your Coca-Cola's position is to say, even if they are, there's nothing we can do about it. Do you still have this? Do you still have this label?
Maybe the two acts are serving different purposes, Ms. Sullivan. I mean, the law that you are relying on is supposed to be concerned with nutritional information and health claims. Not a competitor is a competitor losing out because of the deception. The consumer is able to buy the Coke product much cheaper, and the POM product costs more. The consumer thinks that they're both the same, so buy the cheaper one.
Well, let's assume the following. The FDA just wanted to know what the name should be. That's all they're regulating. That's the only requirement. And it's not even a requirement.
It's an authorization.
It's an authorization. And that's where I'm having a little bit of difficulty, because it's not that you have to use this name. You're permitted to use this name under their regulations. But why are you permitted to use it in a misleading way? That's really I think the government's position, which is if you're using the name in combination with other factors in a misleading way that's not a subject to the regulation, just a name, then it's actionable under the Lanham Act. What the government is saying, nothing about our permission, goes to the size of the name on the label.
Well,
that you can break up the name of the juice into two different sizes so that you're de-emphasizing. It also says that the vignette is misleading because it shows products that have potentially nothing in their regulations say anything about vignettes and how to display them. It's nothing in the regulations talk about using purple instead of whatever that color is or that the juice is, that blue, purple, whatever, instead of the color of apple juice. If you use the color of apple juice in grapes, it would be a light color.
Justice Sotomayor, there are 5 different attacks that POM has made